the United States Attorney should be looking at the federal case law and saying and determining whether or not that you have certain looking at the individuals and say, what's the evidence say? Should these individuals be prosecuted or not? And make some determinations based upon what they understand about the law. Replacing all the United States attorneys simultaneously sends a message to the attorneys. It could send a message from the executive branch. You need to be prosecuting cases a certain way. Okay? Now, would it send that message? Maybe, maybe not. But it could. And then that changes the game in terms of what what the attorneys might tend to look at versus they might focus on one type of case, type of person, etc., because they feel pressure from the federal government. Because, by the way, if they are replaced, they're losing their livelihood, at least until they find alternative employment, right? Because just the threat of replacing large numbers might change the way they tend to prosecute. This, I think, is interesting. So this controversy emerged, right? And there was a little-known provision in the Reauthorization Act of the Reauthorization of the U.S. PATRIOT Act. It eliminated the 120-day term limit on interim appointments of U.S. attorneys made by the U.S. Attorney General. Effectively, what that did is that gave the Attorney General greater appointment powers than the President. Because if there was a vacancy, the Attorney General could fill that vacancy, and there was no 120-day term limit for Congress to vet that person and then exert the constitutional, the confirmation authority. So this was in the act that was passed, and yet it seems as though no one in Congress really put much stock in this portion of the Patriot Act until the question about all the United States attorneys came up. Because if they fire all the United States attorneys, you've got a big vacancy. The Attorney General can put in whomever he or she determines is aligned with their particular viewpoint, and then Congress can't pull any of them back. They rescinded this provision in very large majorities in March 2007, but it was in play when the act was originally passed. Public trial, that's not a military tribunal, right? Military tribunals, what we've heard, any of the military tribunals, there's only going to be a certain amount of information that people are going to be able to see. Impartial jury, I think that's suspect based upon the last few slides, right? And certainly the motives of the prosecutors may be less than ideal. But you also need to be confronted with the witnesses against you. That's trouble when we're talking about people at Guantanamo. Many of the witnesses, much of the information that we gathered, if you read that Guantanamo Files book, much of that information that was gathered is based upon hearsay and other items, and many of the people that were originally interviewed as witnesses are no longer available. Okay? And so you wouldn't even be able to confront the witnesses against you in many of those cases. Eighth Amendment. Excessive bail shall not be required, nor excessive fines be imposed, nor cruel and unusual punishment inflicted. Listen to this interaction in this committee.
Earlier, you discussed the issue of Guantanamo and used the word urgency to deal with the issues. I presume that sense of urgency also goes to the 45 detainees who are currently at Guantanamo, who have been cleared for release by the Department of Defense.
You're talking about the Uyghurs?
No, I'm talking about 45, including the Uyghurs, 45 detainees whom the Department of Defense has cleared for release, who are still being detained at Guantanamo.
And if there are, in fact, 45, and I take you at
Well, let me
that number.
suggest that that 45 list was given to Judge Hogan on this past Monday.
I have no doubt that it's accurate. The fact remains that we are not allowed to release people unless we can find countries that are willing to take them with the assurance that they will not be abused
And I understand.
when they get to those.
And I understand that.
And the State Department has been making heroic efforts at placing people, and it has been, thus far, fairly successful. The list has been sweated down from 775 to something in the neighborhood of 260. So
There's 270 plus detainees currently at
I think there are
Guantanamo.
slightly fewer than that, but
Okay.
in any event.
But we find ourselves in a position as a nation where we are detaining at least 45 individuals who have been cleared for release. You indicated that you would object to having those individuals or any individual repatriated to the United States?
Yes.
Okay. Let me again go to the issue.
Because the reasons why they have been cleared for release do not necessarily go to what havoc they could cause if they came here. They go to a whole lot of other things.
Other countries where they could create havoc?
No.
Right.
Other countries where they could not.
Where they could not create havoc.
Correct.
In other words, if an individual is inclined to havoc, that havoc will be limited by geographical boundaries.
It doesn't necessarily mean that those people were picked up by mistake or that they have ceased to be dangerous at all.
But
It simply
the
means
Department
that
of
there
Defense is
that there
willing
is a
to release
tolerable-
them if they're still dangerous.
The Department of Defense is willing to release them under controlled conditions if they can be put in places where they won't cause us additional harm. The Department of Defense has leaned over backwards, and in some cases we have all lived, and a couple of us have died, to regret it.
With all due respect, these 45, I dare say, if we should release them and they are still dangerous, we are doing a disservice to those of our allies that would be willing to accept them.
He's suggesting that we need to find a place where they can go where, they can't, as he say, create havoc or be limited by a geographical area. There's a number of, I think, problems with that. I think more importantly, when you're detaining people against their will and you've decided that they're cleared for release, some of them are Saudis, some of them are Pakistanis, some of them are Afghanis. It seems as though the best place to put them is back in their home country, right? I mean, many of them were captured in Afghanistan. But if you decide you're going to clear somebody for release, sending them back to Saudi Arabia, if that's where they're from, seems like the most ethical and constitutional option. Then continue to hold them until we can find a place that would be willing to take them. Right? And that seems problematic because I would guess if we interviewed those people, they would say, "Send me. I don't care where you send me, but let me out of the cell." Right? At least in terms of their liberty, that seems reasonable. Now, if you listen, that's describing basically an indefinite suspension, right? They're cleared for release, but we don't know when we're going to be able to let them go. Listen to what Obama says.
I've studied the Constitution as a student. I've taught it as a teacher. I've been bound by it as a lawyer and a legislator. I took an oath to preserve, protect, and defend the Constitution as Commander-in-Chief. And as a citizen, I know that we must never, ever turn our back on its enduring principles for expedience's sake. We're going to exhaust every avenue that we have to prosecute those at Guantanamo who pose a danger to our country. But even when this process is complete, there may be a number of people who cannot be prosecuted for past crimes, in some cases because evidence may be tainted, but who nonetheless pose a threat to the security of the United States. In our constitutional system, prolonged detention should not be the decision of